All right, we're cause number 253-7045, State of Texas versus Emma Lynch. Ms. Lynch was picked up at DWI November 4th of 2024. She was ordered not to consume alcohol or illegal drugs. We now have a bond violation report. Today's date is February 3rd, 2025. Can you please?
Anna Edie for Ms. Lynch.
Okay. So Ms. Lynch we are here now. Again, this also is a second bond violation report. The first violation was November 20th of 24. We now have another bond violation. It is a report that was filed on the 29th. Okay, State, if you'd like to.
There is slow, if you can just give me a moment, but this case is regarding this similar, not of skipping testing as well. And I'm trying to print the bond violation report and the bond conditions, just one moment. But we would call as our witness, pretrial services, Felicia Stiles, again.
Okay, ma'am, would you come up? Would you raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, please.
Thank you, Ms. Stiles. Are you able to show us the bond conditions on your end, if you have them on your?
Yes, would you like me?
Yes, ma'am. Thank you. And Your Honor, we would like, if you could please take judicial notice of the file as well here regarding
Sure.
the
Any
defendant
objection?
being charged for this.
I have no issue with the,
Same as the last one.
correct, with the information.
So no objection to taking judicial notice of the file, however, not of the actual report, of the bond violation report just yet. Let her take a look at it.
Yes, sir.
So again, State's one will be the actual condition of bond report.
Yes, sir. Do you recognize this? Yes, yes. What is this? Bond violation report? Can you please tell us what the bond violations were in this case? Yes. Oh, wait, let me actually refresh that. Do you recognize this? Yes. Okay, what is this? Conditions for the defendant. Your Honor, we will tender State's Exhibit 1 to defense for any objection regarding the bond conditions in this case.
Judge, this says that never mind. I misread that. No objection.
State offers State's Exhibit 1 into evidence.
Okay. Will
Ms.
be
Childs,
admitted.
may you please tell us, thank you, Your Honor, sorry. May you please tell us what the bond conditions are listed in this case that defendant Lynch was supposed to abide by?
So December 3rd of 2024, we have defendant to appear in court on time every time the case is set on the court's docket unless judge waives the appearance. Defendant shall commit no new crime or shall not engage in any conduct that could result in his or her arrest. The defendant was required to obtain a portable alcohol testing device that same day, December 3rd, to submit to random drug and alcohol testing, to not consume any drugs or alcohol. And yes.
These are pretty standard for this kind of case, correct?
Yes.
Thank you, ma'am. So regarding what's been marked as State's Exhibit 2, what is this?
A bond violation report.
Does this fairly and accurately depict a bond violation report?
Yes.
State tenders defense for any objections.
I would just object to, in this State's Exhibit 2 bond violation report, there's a reference to a number of skip tests. There's no dates on here, so I'm not quite sure which ones, based on the four corners of the document, we're addressing.
Okay, I guess we'll be getting into that now.
Right, yes,
But-
sir.
Okay,
State offers State's Exhibit 2.
okay, it'll be admitted.
Ms. Childs, can you please read what the violations were that are overtly obvious in this case?
The client was ordered conditions of bond that included to refrain from alcohol consumption, to obtain and be monitored by portable alcohol testing device, and to comply with required monitoring, testing, service recalibration protocols. The client was instructed to not obstruct the camera on the device and do not skip any testing windows, 5 a.m. to 8 a.m., 5 p.m. to 8 p.m., 10 p.m. to 12 a.m., blow into the portable testing device 3 times a day in accordance with the blow schedule to ensure compliance with the ordered conditions. There was a high breath alcohol content of 0.03 on 1/10 of 2025 at 10:38 p.m. The client blew into the device in the dark and her face was not able to be seen. The client failed to clear the high breath alcohol content and the allotted time. The client is also not blowing into the device as instructed. The client has a total of 15 skip tests.
And tell us what your role is in the courtroom,
A judicial liaison officer.
and you're able to testify to the bond conditions and to the bond violations.
I can testify to the bond conditions. I did not generate the bond violation report myself.
But can you attest to these dates in which the violations occurred?
I have not looked over the report recently, so I don't want to say yes.
But this is the bond violation that you've seen before.
Yes.
Okay. And it is true that the defendant here is on bond in County Court 11-5?
Yes.
I'm sorry, go ahead.
We pass the witness.
Okay.
Okay. Ms. Giles, part of your job is to read the reports when they come in from the case managers,
Yes.
and then you file the bond violation report.
No, they filed the bond.
They file the bond violation
Yes.
report, and then you coordinate the,
Yes,
that with
the
the judge?
action and the
Okay.
review of it, yes.
okay. Are you able to verify the information in the report?
If I have the report, which I should in my email, if
Okay.
I take a look over it, yes.
Okay, but the only way you can verify the report is from the report itself.
Yes.
Okay, so you have no personal knowledge of the machine itself?
No,
You have no knowledge of the software
no,
and no knowledge of how the hardware and the software work together?
no.
Okay, no further questions.
Okay. Anything further? The witness?
No, Your Honor.
Okay. So she has the first violation, right? This is the second time we have a bond violation, right? And the first one, was it that she just didn't get the device, right?
Yes, that's when we were going back and forth on the dates to get it, and
We kept resetting the case because she said that she was gonna get it and then she didn't, and then we were gonna revoke her, but then she didn't come to court, so then we sent her again, and then she didn't get the device that day, so then we gave her another chance.
Okay.
And
All right.
Judge, I don't think I represented Ms. Lynch the whole time on that, but I think some of the confusion was she was ordered to get the in-vehicle interlock and she didn't have a card.
But you did come at the time to where
Yes,
she
correct.
did get the device
And then
within,
once Ms. Lynch because I believe the vehicle was damaged in an accident and she was hoping to get the vehicle out and get it repaired. And when she realized that wasn't going to be possible, she got the portable device.
My car's fixed now.
Yeah.
I started getting.
Okay, we'll get to that in a minute.
my concern is that it continues to happen. What am I supposed to do? The problem is if I let you go, I'm telling you the behavior is okay for you to do. It's not. We have court orders. You're supposed to follow court orders. You're doing what you want to do. That's not the way it works.
For revoking. There it is.
Look, this isn't, I'll let you talk with your lawyer, but it's there. It's continuing to happen. You're skipping and you're continuing to consume alcohol. I'm sorry. I'm going to revoke your bond, man. She goes with you.
Judge, maybe
Go back and I'll talk to you.
Anything else?
Judge, since she does have a vehicle, if she makes the new bond, can we switch her from the portable to the in-vehicle?
Yeah.
Okay, thank you.
We are back on the record in cause number 252-6407. State of Texas versus Sierra Torrance. Please, guys, if you announce yourselves for the record. State.
State Kelsey Stiegler.
The state, William Thomas.
Anna Edie for Ms. Torrance.
We have reset this thing at least 4 different times, I would imagine, because of this bond violation. One, I guess, evidentiary reason for Ms. Edie to get evidence. Last time we were here, we were going to have a hearing. Unfortunately, we didn't have our pretrial services officer here. She's here now. So that's why we're having this hearing now to determine whether there is a true bond violation. Ms. Torrance is on bond for a DWI that was initially filed August 28th of 2024. It's a second offense. So she was ordered to obtain a guardian interlock, or if she was not going to drive, obtain a portable device, and to blow in this portable device as according to the below schedule. Our first bond violation report was filed October 8th of 2024. I'm correct in saying that no action was taken on that bond violation.
She was admonished
I
and
admonished her. We did not do anything at that time. We now have another bond violation report that was filed January 24th of 2025. And in this bond violation report, we have 13 skip tests on random days. And then I think that there were other issues as well. But I guess for me, the main concern would be that she's not testing when she's supposed to. The floor is yours, Miss Edie, if there's anything that you wanted to say.
okay, well, let's see. The only thing I see alleged in the bond violation report is just the skip test. So I just want to make sure we're all on the same page. I don't know that there's any other allegations.
Okay.
That's correct. Okay, okay. This is not my hearing, Judge, so I don't, if the state wants to call somebody or, you know, they have the burden, so whatever they want to do, I'm happy to respond, but this is their,
Your
So
Honor?
tell me what happened with the missed test, if you don't mind.
Yes, Your Honor, we can call pretrial services Miss Felicia Chiles if she is available for one moment.
Okay, do you mind coming up? Raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay? State.
And first,
Judge, would you please take judicial notice of the court's file, which is a copy of the information?
Okay. Any objection?
I'm okay with the information. I would object to taking judicial notice of the report.
Okay.
So I'm not sure what all is included in the file.
we were addressing about the defendant here being charged. That's why we're asking for judicial notice of the court's file regarding
Okay.
that element that we need to prove today.
Sure.
So
All right, Ms. Chiles, Giles, apologies. Is the defendant on bond or court of law number 5?
Issues?
Yes.
Yes.
Are you familiar with the bond conditions?
Yes.
Your Honor, may I approach?
Yes, sir.
Is this a fair and accurate representation of the bond conditions for the defendant?
Yes.
You recognize that?
Yes.
What is it?
They're the magistrate's conditions for the defendant.
In order to the defense, Your Honor?
Okay, please. Any objection?
No objection.
Okay, they'll be admitted. States 1, I guess.
yes, sir.
Okay.
Could you please describe the bond conditions?
Yeah, you want me to read all of them? Or like all of them?
Yes, we're the ones that have checked.
Yes. So we have defendant shall personally appear in court on time every time the court, this case is set on the court's docket unless judge waives the appearance. Defendant shall commit no crime or shall not engage in any conduct that could result in his or her arrest. We have here that they're to obtain an ignition interlock device within 7 calendar days. Is this the most recent condition? Doesn't she have a portable device? The device. Are these the most recent conditions? Because these are the IID ones. Can I have a moment to look at that?
Yes, please.
These are not the most recent bond conditions for the new case. These are the first ones from the magistrate. Right now I'm printing out the amended bond conditions that were created on September 4th, the ones that we're referring to with the portable device. So the first two conditions are the same that I had stated. However, instead of the ignition interlock, we have the client is to obtain a portable device within 7 calendar days. And that would be from the date of August 28th. And then no driving without permission of the court. We have no drug or alcohol usage. And then that same day, the defendant also was required to submit to a POC test and return to court.
Your Honor, would you like me to consider these updated
Sure, of course.
with the defense?
So I guess states 2 would be the amended conditions of bond.
We're calling this stage 3, if that's okay, Your Honor.
Okay, sure.
I have no objection to this.
Okay, it'll be admitted.
Now we will be addressing the bond violation report.
Your Honor, may I speak as the witness?
Sure.
You recognize that?
Yes,
Is that called?
it's the bond violation report.
Is that a fair and accurate representation of the bond violation report?
Yes.
All right, could you please explain the violations of?
Objection, she's reading from something that hasn't been admitted yet.
Mistake, Your Honor. I can consider this to the defense.
Oh,
This will be admitted as State's Exhibit number 2, Your Honor.
Okay,
no objection.
all right, it'll be admitted.
Can you please read where it says details of violations indicated here?
Yes, the details read that the defendant was instructed to obtain a portable alcohol testing device and refrain from alcohol consumption. From December 9th to January 14th, the defendant has generated 13 skip tests. Pretrial is unable to properly supervise the defendant if the defendant is failing to provide samples during the scheduled timeframes.
But wasn't it a condition of bond to complete those portable tests?
Yes,
And how many again were not completed or were missed?
13.
And what were the dates?
Between the dates of December 9th and January 14th.
Thank you.
Any further questions for the witness?
No, Your Honor.
Okay,
Do they prepare a report of the missed blows with the specific days?
Yes, and that was provided to everyone here's email last week or
Okay.
the week before when we had discussed it.
Okay, Ms. Giles, what is your job title, exact job title?
Judicial liaison officer.
And what do you do as part of your regular duties?
I am the face in the court for pretrial services, so I create bond conditions that are requested from judge and instruct clients over things that I can instruct over, so conditions that don't require devices in court. And if not, I send them over to our pretrial services building for further instruction.
Okay, do you know how the portable device works?
I'm very partially familiar, but not thoroughly, no.
Okay, do you know how the software in the device works?
No,
And do you have any idea how those work together?
no.
So when you get a report, you have no way of verifying whether that information is accurate.
The vendor sends us the full report to our case managers.
And was the full report provided in the email that you referenced earlier?
Yes,
Okay, but there's no way to know that that device is working properly from your personal knowledge.
for me to validate if it's working
Mhm.
correctly, me personally, no, but our case managers do verify it.
Okay, I don't have any further questions for this witness, Judge.
okay. Anything further?
No, Your Honor.
Can the witness step down?
Yes.
Okay, thank you so much. All right, it's argument. Or do you have any more witnesses?
No, Your Honor.
You have any witnesses?
I do not.
Okay, argument.
So, Your Honor, this case is pretty clear. It's a simple bond violation. The defendant here was in fact charged. We ask you to take judicial notice of that fact. And we have proven such, and that this defendant is on bond in County Court at Law number 5. And we just discussed the bond conditions that were pretty standard. And the violations here very clear that there were 13 missed portable tests. And our pretrial services was able to confirm that, and we would ask that you would revoke the bond in this case.
Judge, this is, the rules of evidence apply at this hearing. This report is testimonial. Since it is testimonial, I have the right to confront someone with knowledge about whether the machine itself was working properly, whether the software was working properly, whether the two were working properly together. And we reset this to today to get someone here who had that knowledge, was my understanding. And without that, I can't.
I didn't know about that. The only one that I knew that we were supposed to have here was Ms. Childs as with
Yes,
regard to
Your
this, not anything else.
Okay, well-
Okay,
And we
go
would
ahead.
say that the defense also has the ability to subpoena as well.
And this was set on Thursday, and it's also not my hearing, it's not my burden. I think without someone to testify that the machine was working properly, it's inappropriate to revoke her bond, restrain her liberty, the pecuniary punishment that goes with the bond revocation and paying a new bond, without knowing that the machine was working properly.
But that's on them. If there's a problem with the machine, then it's on them to go have its service or whatnot. So
Does she know it's
all I
working?
know, well, then you're supposed to go there. You're supposed to go get it checked out. We can't micromanage every single thing. Number one. Number two, this is not the first time we've had this bond violation. We've had it before and it continues to happen. I can't just let it go, man. I mean, I have to show you that we mean business. If I let you go now, then I'm enabling this behavior and I'm in effect telling you it's okay when it's not okay. You're skipping tests. It's a second offense. It's done. All right. I'm revoking her bond. She goes with you. It doesn't make me happy to do it, but I mean,
I
it's
understand.
bond violation after bond violation. I mean, all right. Off the record. You are on bond for a terroristic threat, and now you've picked up a new case. You now stand charged with the offense of driving while intoxicated. First offense, it's over a 0.15, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Alex, do you mind? This is Proctor, please.
Yes, Judge.
The new case, the DWI.
On January 24th, 2025, the officer was dispatched to a vehicle accident on Conklin Lane, Harris County, Texas. The officer observed the defendant's vehicle stuck in grass, and the officer made contact with the defendant, the driver, and sole occupant. The defendant stated he was going fast and lost control because he hydroplaned. However, the officer observed no water or ice on the road. The officer observed glossy eyes in the defendant's one eye, slurred speech, and a strong odor of an alcoholic beverage. The defendant stated he was on his way home from NRG as he was at a rodeo event. The defendant stated he drank 2 beers and standard field sobriety tests were administered, HGN 3 out of 6, and the walking turn was unable to be performed due to equilibrium being off from the defendant only have one eye. The one leg stand was started, but the defendant stated he could not do the test 20 seconds as the test had already been started. The defendant read the DIC and consented a breath. The results were 0.161 and 0.155.
All right, Mr. Proctor, I'm going to find that there's probable cause to go forward with a new case. We have not addressed the old case, correct?
No, sir.
Okay. Because you're on bond, you picked up a new case. I'm now revoking your bond on the first case. Goes with you. The bond is set at $5,000 now, James. I usually, when it's, would you raise it up to 5,001 now because it's 5,000? I guess I'll do half and I'll do it 7,501.
Okay. I was hoping maybe on the probable cause issue first.
Oh, tell me if you have an argument. I'm all.
Well, it's got one eye, so the tests are off. So all you have is him just saying I had 2 beers as probable cause of intoxication.
But you know that's not. I mean, you take it as a totality. There's all the other.
Your Honor, respectively, they observed HGN in the one eye, the 3 out of 6. And that,
I don't think you can do
still
that.
have the odor. And they still have his statement being that he drank 2 beers and then also his refusal to do the test. And then as well as
You have an accident.
and the strong odor of an alcoholic beverage.
I mean, you have a
So
breath test it's twice over the legal limit as well, allegedly. So, I mean, I think that there's enough to go forward for probable cause purposes. Beyond a
Okay.
reasonable doubt, I don't know, but I think there's enough. It goes with you.
Well, he's got one eye, so I got to at least try.
I got it. I understand. And,
Okay.
and look, I wouldn't take credence in that test anyways, you know? I mean, even assuming it's done all correctly, what it's 77% chance as it is.
Gotcha.
Yeah, but taken together the totality of everything else, I think it's sufficient. So,
Okay. What about instead of revoking the bond? Because what we did last time with Judge Andrews was she kept the bonds the same, and we let him out, hoping that the conditions on the DWI would satisfy any threat to the community.
no, I want him to get it. He's not getting it. And so,
Okay.
I mean, if he's unable to make bond, come back and we can talk. But not now.
Okay, so what was the new amounts now? Or the new amount?
7501 on the, I'll leave the DWI as is, but 7501 on the terroristic threat. He will pop up on tomorrow's docket, James. So,
I'll see you
yeah.
tomorrow. Okay, cool.
Okay.
All right, thank you.
Take care, bud.
Judge, I have 2 on the docket. It looks like one is going to work out. Natalie Garza looks like it's going to work out.
Okay.
Once we get restitution established, that one should be dismissed. But we're just not there yet, but we're all in agreement.
Okay.
We just need to make sure that the number is correct.
It's kind of old though, and we've had the restitution, $500 restitution in class for dismissal since January.
We're just waiting to get the proof of the insurance from the complainant. I called twice just now and I'll call again this evening to see if I can get a hold of that today.
I'm gonna roll it a week.
I'm cool with it. We're in agreement, Judge, so a week is fine.
Got it.
And hopefully if they can get it earlier, we'll get it in earlier and she doesn't have to appear. And also, Judge, I understand that Tristan Smith needs bond conditions for the second case, so I'm here to approach on Tristan Smith.
Come up, Mr. Smith. We didn't do conditions on it?
Oh, we did. Victoria said,
Condition.
I think we're good.
Tell me, how are things going? Great. Okay. That's the best news I've heard all day. Really.
They're like unenrolled in Channel, but I wasn't gonna be able to go to Channel anyway because it's too far of a commute. So
Yeah, that's crazy.
yeah, so they just enrolled me in Humble High School. So my first day will be Thursday.
Knowledge is power. When you know things, you can do anything. I'm telling you, ask him. When you have knowledge and when you know things, it can take you so far in life. The only way you do it is by doing school, taking it seriously, and not letting other people drag you down. Because that's what you constantly have is people around you trying to bring you down. Don't let them. Be stronger. Right here, that's where it starts. When you see someone trying to take you down, even though, hey, let's go out, let's do this, it's bringing you down. Don't let it. Be stronger. Be strong-willed. Make something of yourself. And it starts, prime example right here. He's amazing, right? That's a great role model right there. You ever need anything, that's who you follow. We have things here that we can help you out too. What conditions do we need?
I thought that we needed
Alicia,
somebody.
do we?
Did you want me to go over the ones that we have?
No, I mean, I think that the only thing we need is just stay in school, get a job. I would prefer you stay in school, get as much education as you can, so you become someone, go to law school. It's an amazing field. I'm telling you. Okay. I mean, I think we're good,
Yes, sir.
just don't pick up any new cases. Be good. Okay. All right,
Thank you,
friend.
Judge.
Mr. Garza, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Yes, Judge. On January 26, 2025, the officer was dispatched to a crash that occurred at 10200 Beaumont Highway and observed a white Chevrolet Blazer with minor front end damage and both the driver and passenger side airbags deployed. The officer observed a male leaning against the rear passenger door of the vehicle, and when speaking with another officer, the other officer advised he observed the male exiting the driver's side of the motor vehicle. The officer observed no other individuals in the immediate area of the crash, and the officer made contact with the male, now identified as the defendant, and noticed a strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, and wet stains on his shirt consistent with the smell of an alcoholic beverage. The officer also observed the defendant swaying, staggering, and stumbling while speaking. The defendant advised he was coming from the flea market and was en route to his home. When asked how he crashed, the defendant stated, "I was driving and I crashed. I don't remember." The defendant also advised he ate at a restaurant and drank beers there. The defendant stated he had 4 to 5 Modelo beers at the flea market, and the officer observed a cold red cup in the center cup holder of the motor vehicle with approximately a quarter of liquid inside that smelled like tequila. The red cup had 2 limes inside. Standard field sobriety tests were then administered. When asked to perform the walk-in turn and one-leg stand, the defendant refused, and the officer found 4 out of 6 clues on the HGN. The defendant was read the DIC and refused a breath sample. A blood search warrant was signed and executed.
Mr. Garza, I'm going to find that there's probable cause to go forward with the case. I would hope that you recognize it's elementary, that you're not to have alcohol in the car while you are driving. In fact, it's a minimum of 5 days in jail to any sentence that you get upon proof of that. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, it's very possible they put an immigration detainer on you and you will be stuck like Chuck in custody until the case is over with and then shipped off to immigration. I am now putting bond conditions on you. If you violate these conditions, I will revoke your bond and put you in jail. And like I said, if you're not in this country with permission, you could be sitting in there for a very long time. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, you will go to jail. I'm also forbidding you from driving. You will be signing with me today a promise. This is an affidavit that you're not going to drive. I don't care what is going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm going to have you come up here, swear to us that you're not going to drive. After that, I'm going to get you to Victoria, where we'll have you sign a reset. And after that, I'll get you to Felicia for your bond conditions. Be careful what you do, because like I said, any of these conditions, I'm just going to lock you up. Do you understand?
Yes, sir.
You were charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Dice,
On January 27th, 2025,
2025.
on 11402 North Houston Road, the officer observed the defendant stopped in the intersection facing northbound. The defendant was observed to be asleep behind the wheel of the vehicle, which was running. The gear shift was in drive, and the defendant's foot was on the brake. Multiple attempts were made to contact the driver. None were successful. Houston Fire Department and emergency medical services were contacted, and the vehicle was locked, but responders were able to unlock the doors and put the vehicle in park. The officer observed a strong odor of an alcoholic beverage, bloodshot eyes, and glossy eyes. Standard field sobriety tests were performed back at the station. HGN 4 out of 6, walk and turn 8 out of 8, one leg stand 4 out of 4. The defendant was read the DIC and consented to breath. The results were 0.186 and 0.194.
How many prior DWIs does this gentleman have?
He has one prior, Your Honor.
Have you run an NCIC?
Yes, Judge.
License?
I'll run that right now, Your Honor.
No. Say no.
No.
He said he doesn't have a license.
Yes, Judge, there's no license on file.
Mr. Mazariegos, let me make something perfectly clear to you, that I'm ordering you as a condition of your bond not to drive any vehicle. I don't care what is going on in your life. I don't care if there's a burning building and you have to save 50 children. If you do not have a license and liability insurance, then you are not allowed to drive. I am now placing an additional restriction on you, that I'm going to have you take a portable breath test device with you everywhere you go to prove to me that you're not consuming alcohol. If I find that you consume alcohol, if I find that you use illegal drugs, I will revoke your bond. I'm going to put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail any more than 4 hours, immigration sweeps the jail on a daily basis. They will put a detainer on you and you will sit there until this case is over with and then shipped off to immigration. Do you understand?
Lo entiendo. Conteste palabra. Lo entiende? Yes.
You're signing a promise with me that you're not going to drive. I don't care what you're doing. Do not get into a car.
Okay, yes.
I'm sending notice to the Department of Public Safety that every officer in this state will know if you were in a car driving, you are supposed to have an interlock in that car. If they catch you driving a car that doesn't have an interlock, they're going to arrest you and put you in jail.
Tiene el almacenamiento, van a estar en gaslight.
Sí, yo no voy a tener carro ahorita.
I don't have a vehicle at this time.
La máquina portátil está bien.
The portable.
Don't use anyone else's car
El vehículo
don't-
de alguien más.
at all.
Okay.
I'm going to have you come up here, swear to us that you're not going to drive.
Okay, no.
After that, I'll get you to Victoria. We'll have you sign a reset. After that, you'll get with Felicia for your bond conditions. Mr. Mazat, sir, do you have are you working now?
¿Estás trabajando ahorita?
Sí.
Yes.
What do you do for a living?
Relación.
Remodeling.
Yeah, is that a steady income for you?
¿Trabaja todos los días?
Sí.
Yes.
You have the ability to hire a
¿La
lawyer.
capacidad para ocupar tu propio abogado?
Sí.
Yes.
Okay, we will give you time, sir. So I'll have you come up here with all the appropriate documents and then we'll get you out of here. Do not consume alcohol and above all else, do not drive.
Anega.
Okay? Come on. Good morning, Mr. Martinez.
Good morning, sir.
So you're charged with 2 cases. You're charged with terroristic threat. You're also charged with assault of a family member. Looks like you guys have worked out an agreement where they're offering you a 13-month deferred. That is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. You can't tell people it was dismissed. It doesn't get dismissed. You take a probation. If you complete it successfully, you don't end up with a conviction on your record. This is extremely important. The other thing that you need to understand is that with this case, there's an affirmative finding of family violence. Shh. There's an affirmative finding of family violence.
Yes, sir.
You ever pick up another case like this, you will be looking at a 3rd-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. And it doesn't have to be something where it's a dragged down fight where there's fists and this. No. All you have to do is squeeze someone's arm enough to where it hurts. Boom. You're looking at a 3rd-degree felony. You understand?
Yes, sir.
It's any pain. Pain is a very loose term. It's not what you think, it's what the other person perceives. You understand?
Yes, sir.
Now, for you to complete this successfully, you must do what's called a TRAS, which is an evaluation to see what conditions you may need. You must do substance abuse treatment. You must also do what's called a BIP class. That's a Batters Intervention Prevention Program. This is a difficult one. You have to go and do a class once a week for 18 weeks. If you fail to appear for the class, they're going to kick you out and I'm going to issue a warrant for your arrest. 16 hours of community service, no threatening or harassing abusive contact with a Mr. Pipkins, no drugs, no alcohol, $100 donation one time to the family violence. It says family violence provider, or should it be?
Call it center, Judge. Call it me center.
Should it be the Houston Area Women's Center?
Let me see, Your Honor.
I've never heard of it.
Judge, I mean, it's just language that would include things like Houston Area Women's Center or any organization.
Okay.
I do need to work on wording.
Yeah, I've never heard of that. So if,
Houston
It's
Area
just-
Women's Center, Judge.
Yeah, any
can you put it to
organization.
Houston Area Women's Center? No weapons as well. I'll make you a deal. I would prefer him to do a class instead of the 16 hours community service. So perhaps like a effective decision-making class in lieu of that at his choice, if he would prefer to do that. A more menial tasks, picking up it makes no sense. I'd rather you learn something from this, and like an effective decision-making class is something that you can do at your leisure instead of just doing menial work it makes no sense.
Thank you, Your Honor.
And I'll make you another deal, Mr. Martinez.
Yes, sir.
If you're clean, if you're nice to everybody, you get your classes done quick, I'll take you off in half the time as a reward for you doing well. But I want you to understand, if you pick up a new case, if you don't do your stuff on time, if something else happens, I'm going to issue a warrant for your arrest. I'm going to put you in jail. You were looking at an entire year if you violate this probation. Do you understand?
Yes, sir. Thank you, sir.
Well, it's not hard. 90% no self-control. That's why they're in custody. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you enter into this agreement with us, you are stuck with us until you complete it or unless it gets revoked. Do you understand?
Yes, Your Honor.
Now, like I said, as an added incentive, you can be done with this thing in 7 months if you do really well and kick butt. All right?
Yes, sir.
How do you plead to the offense? Guilty or not guilty?
Guilty, sir.
I will not find you guilty. I'll withhold it for 13 months. So you work at PetSmart.
Yes, sir.
It reduces fees. All right. It's never about the money. I don't care about the money. So don't worry about the money. Just do what you say you're going to do. Be nice. Don't pick up any new cases. All right?
Yes, Your Honor.
All right. Good luck, Mr.
Thank you, Your Honor.
Thank you, Mr. D.
Yes, sir.
Hi, Joe.
I'm here on Cesar Hernandez.
Okay.
Your Honor, we are still working on getting everything in for the PTI. You talked to him last week.
He promised that he was going to have the payment in, and then someone came in last week, late Friday, saying, "Oh, we need more time." I'm like,
I wonder if I could explain. And he's here to explain too. He said you had offered him, he told you he didn't get his check till Thursday and that you offered him, okay, then after that, we'll set it. Instead of setting it for the next money, they set it for this money. So he came today, but his check doesn't come till this Thursday. And that was the whole purpose. Then as
I
far as
see. Okay.
the machine, I said, well, what about the machinery? You have to still get the interlock. He said, well, I don't have any money for that. I'm still waiting to get money to pay for that as well. Because the original was to pay the DA fee for the PTI. That was going to take a large part of his payment of his check. So that is what we were working on, Your Honor. And I can bring him up there. He seems pretty credible and he's trying to get that done.
So when do you want?
Well, he wanted to, I can bring him up there because he's working on putting the interlock device in. Can I bring him here? So Sir, he knows that your check.
So you get paid what day?
This Thursday.
It's Thursday.
Coming
Okay.
up. Last time we came in, I stayed behind because I saw the reset form instead of third. And I believe you said roll over to this Monday coming up. I can get, the machine this week and then I can for sure pay the DAP on Thursday. I pay my bills today and if I could, I would, I know it's been.
I believe you. So do you want to do Thursday? So we can reset you to Monday then?
Good, I really appreciate it.
Okay, we'll set you to Monday.
Okay, thank you.
But you got to have it all done by then, huh?
Yeah,
Right?
yes, Your Honor, I got
So you
it.
pay the DA fee and then have the interlock.
Okay, yeah, yes, sir.
Okay, so but call today for the interlock. Don't wait till Thursday.
Okay.
Because you need a couple days to make the appointment
Okay, so I'll set
or for the interlock.
I think I contacted the lawyer's office. I think I signed the one for the interlock. I signed the affidavit for the no driving, so I'm trying to get the portable one.
Okay, but regardless though, you got to call to make the appointment to go get that portable today for the upcoming week.
Okay.
Don't wait till Thursday or Friday to call to make an appointment because they may be booked. And then they may say, well, we don't have anything for another week. So that's what I'm saying. Call today to make the appointment. And then when you go get it, you pay for it to get it installed.
Okay.
Whether it be Thursday or Friday or whatever day you want to do it.
Take care of it. Thank you so much.
Okay.
Thank you,
All
Your
right.
Honor.
We got you, Joe. Thanks. Just let Victoria know, huh? Yeah. Chuck, you were charged with driving while intoxicated. You are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 6 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. Whenever you get pulled over, an officer, the first thing they do is they look at your criminal history. If they come to your window, they smell alcohol, and then they look you up and with a prior to DWI, it's probably not going to go well for you. Do you understand? Shh. From now on, you are facing a minimum of 90 days in jail. So if you're not in this country with permission, you do that kind of time, you can almost rest assured that you'll get an immigration detainer. Do you understand? What I'm trying to impart to you is that if you want to drink, don't get into a car. Even a sip of alcohol, you're going to end up with us. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. You understand? Do you still want to do this?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'll find you guilty. I will follow the agreement. I'm going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you, sir. All right.
Judge, what about the,
CC.
is it true that he had a,
Oh, I'm sorry. Is it true or untrue that you had a 0.15 or above in your breath test or blood test?
That's what came out of it.
Is it true or untrue?
Yes, it's true.
Okay. All right, guys. Good luck. How's jail?
Como caí en la cárcel.
¿Cómo te gusta la cárcel? ¿Cómo te gusta? ¿Te gusta la cárcel?
No, no me gusta.
No, I don't like it.
Good.
Muy
You're
bien.
not supposed to.
Dale.
No.
The idea is that we want our community safe. And when you endanger our community, there are places that we have for you. I will tell you now that it appears your lawyer is telling me that you've made an immigration bond. And let me tell you that you are extremely lucky that that has happened. If you become a danger, I'm going to revoke this bond. I'm going to put you back into jail. And I'm going to tell you that if you get your immigration bond revoked, that's a lot of money that you're going to lose. So when you get out there in the free world, make the right decisions. Do not pick up any new cases. And I now am going to put bond conditions on you. If you violate these conditions, then I'm going to revoke your bond and put you back in custody. Do you understand?
¿Usted lo entiende?
Sí.
Yes.
You're not to have any contact with the complaining witness in this case.
That's right.
You're not to consume alcohol or illegal drugs. You will also not be in possession of any weapons as well. You understand these conditions?
¿Usted entiende estas condiciones?
Sí.
Yes.
You must also remain in constant contact with your lawyer, and your lawyer will tell you when you have to come back to court. If he tells me that he's unable to get a hold of you because you're playing games or you take off going somewhere, I'm going to revoke the bond and issue a warrant for your arrest. You're going to be called upon to do random drug and alcohol testing. If you fail to show up for the testing, then a warrant for your arrest will be issued. Okay? We will have you sign conditions indicating that you understand and that you're going to comply with these conditions.
Estas condiciones.
And after that, you'll be free to go.
Oh, thank you, Judge.
All right. Thanks, guys.
Yes, Mark.
On the jail docket. If you miss a test again, I'm going to revoke your bond. Do you understand? We have bond conditions in place. You're supposed to follow these conditions. I'm giving you notice now. Your excuses mean nothing. I'm giving you a pass now, but it's not going to happen again. I'm sending you for a test now. If this happens again, I'm going to end up probably revoking your bond. Do you understand? Okay?
Is there a way I can get a test closer to where I am? Because I don't.
I'm sending you for a test now.
Okay.
That's what's going to happen now. If you fail to go test, if you fail to show up, I'm going to revoke your bond. Do you understand? Okay. Good luck. Thanks, Connor.
So she is enrolling and going to the IOP, but the provider told me she was supposed to finish on February 18th, but she advised them that if she's struggling financially, he said he will talk to her and see what they could do to work on these, but they won't release the certificate until everything is.
But she is attending, because whenever we had the issues back when you stressed on her that she needs to go, and I wanted to make sure that everybody's aware that she's doing that. She's attending every session. She's on track with that. She just needs, how much time do you need to? Can she focus on paying the IOP SOP so we can get those certificates and then we'll figure out the devices? Or would you be willing to get rid of her ankle monitor? That's like $350 a month. So maybe she can take that money and put it towards the IOP SOP classes. We haven't had.
You have now.
You have the in-car as well, right?
Mm-hmm.
She has the in-car and the ankle monitor.
And the problem is I'm never going to know whether she's using, and the only time is whether she's in a car, and we can't trust her though, because we've tried this.
Maybe you couldn't trust her a few months ago, but she's been good. She's been really, really good. She's been coming to court. Remember, she was coming to court every week and then every couple of weeks, and now she's coming once a month.
Yeah.
So she's been doing great. So I'm just trying to figure out a way to.
How do you earn money now?
Well, I'm a full-time student, so I don't
Where do you go
have
to
a
school?
job. I go to both UH and Lone Star. I take two, like, dual classes.
So how do you survive now? Because you still need money.
She's with
For
her
my
parents,
classes?
Judge.
Sorry?
Oh, for my classes or?
No, Judge is asking you, what do you do for money? Who gives you money to
Still need to
drive?
eat. You need
Oh,
to,
my parents.
do you live with your parents now?
Yes, my mom.
When is, I mean, the problem is that we've tried this before and every time we like let her, we give a little bit of leeway. She just
We've had
picks a
issues
yard
once before.
every single time. And we've been dealing with now.
No, Judge, you say every single time, but we've had one time, this has happened one time in the past. So this is when we had the issue.
Ramirez.
Ramirez.
I mean,
It hasn't been multiple times,
we've been
Judge.
dealing with this for 825 days.
Yes, because the case was older. I don't know if you remember, she was ready to be done, close to being done, and then she tested positive that time. Then one time, she tested positive. It was just a high positive, but it was a one time. And that
It was like multiple skip stuff, wasn't it?
She was admitted to using alcohol. I think she went out for her sister's birthday.
right, and that's the one time when she tested positive. And then we came before you, and then
Ones that we know of, right?
what, Judge? No, that doesn't mean that she did it multiple times. There is a one violation.
But I don't know. And I can't,
But then we can't make the assumption that she did.
so if we were to take it off, is she reporting, where does she report to?
She's reporting to probation office.
So could we do, if we were to take it off, we do enhanced, like a lot more.
Or Judge, another option, if you're open to it, put her on a blow schedule for her in-car. And then you have her monitored if she's on a blow.
It's a great idea. Can we
And
do
that
that?
way we can get rid of
It's a
the.
great idea.
So she doesn't have to come
No,
for
that's a great
REAs
idea.
and all that.
I'm happy to do that. I don't know why it didn't occur to me about that, but yeah. That's a good idea. But I want, I don't care if we're telling you to blow at midnight, you have to blow at midnight. If you come up with an excuse, well, I can't do this. I don't, you know what excuses mean? They go in one ear, they go out the other. I don't care for excuses. Do you understand?
Yes, sir.
So, I mean, this is absolutely no tolerance. Okay, so let's do that. We'll do,
Remove the ankle monitor. But if she doesn't come up with the money by the 18th, she said she'll do everything that she
then, I
can.
mean, we'll just keep going. I mean, I guess, so to speak, right? Until she gets the money that she's, the incentive there is to get the money as quick as possible because you want to be done with this, don't you? So, right. All right, so we need to craft a blow schedule because I also want her blowing not only at midnight, but, Okay. All
Thank you,
right.
Judge. Okay, have a seat. I'll come talk to you.
Good morning.
Approaching on Mr. Kabir, Kabir. So he's here on a bond violation and also we were going to set this for trial as well, Your Honor, two separate matters. It's a Scran violation on January 16th and 17th. It's labeled as his third, Your Honor, but I think it's technically really his first that it's had alcohol detected because the prior bond violations have been, I guess, like he wasn't using his car enough, so the battery would shut off the IID. I would ask the court to take that into consideration.
So the first time he was in lockout, so it wasn't getting.
Yeah. I'm just saying this is the first bond violation that's alcohol's been detected, Your Honor.
Felicia,
Yes, Judge.
on Mr. Kabir, the fees are waived, no?
There should be, yes, I can double check for you just.
So how does it go in lockout? Because it says client,
Check it's the recalibration. They're instructed to report to the vendor. I believe it is.
no. It says here, as of 8/11/24, client's ID has been in lockout due to non-payment
Let me double check.
and failure to report, but I waive everybody's.
Yes.
And you're saying that
Come up, Mr. Kabir.
According to the conditions of bond, they are waived. And it's very clear that they're waived according to the bond conditions. So I'm truly not sure what that is. I can reach out to the case manager further. Maybe there was like
a mistake.
So what's going on now with Mr. Kabir? Why do we have yet another bond violation? I mean,
Well, Your Honor, it looks like this one is for alcohol consumption. That was on the 16th through the beginning of the 17th.
right now. And then I'm gonna roll up to tomorrow. I'll see you, Mr. Kabir.
And Your Honor, since we're here, it seems like the offers from the DAs have been exhausted, so we're ready to set this case for trial.
I want to have a hearing on his, whether I'm setting it for a test.
Sure.
I'll look to tomorrow.
Okay.
I want to have a hearing on it because I mean, it's just too many
I
violations
understand, Your Honor.
and things.
Sure.
Just too much drama, Mr. Kabir. No. All right, I'll set it for tomorrow and then I'm setting it for a test now. Okay, thanks. Hi.
Good afternoon, Your Honor.
Hi.
I'm touching on my client, Mr. Kemp.
Okay.
I wanted to,
It was our understanding that you didn't put any bond conditions on Mr. Kemp.
No, I want, do you have
Did you sign
any,
PC on this case?
do you have any argument?
I do.
Tell me. So I'll refresh my memory because I don't
This is
remember.
where, my client's mother was having like a heart failure.
Oh, that's right. Okay, so moms
EMS
have,
was called. He called EMS, right?
wait, who,
To my client. His mom called.
she has a medical episode. They're trying to
They're
administer.
trying to get her to the gurney and someone's trying to get to the side of the gurney and replace a family member. And then that EMS is grabbed by the arm by the defendant.
At the time, he was emotionally distressed due to his mom's medical emergency. It was more of a protective action. It wasn't any type of, there was no clear harm to the EMS. I mean, when we look at this.
Stop. Don't.
Okay, go ahead and sign.
You're saying he prevented an EMS worker from,
Performing their duties and getting to the gurney to assist the mother because she was on the gurney and while she was trying to replace a family member who was on the side of the gurney assisting to get to the gurney, he grabbed the EMS worker instead, specifically, nah, don't fucking, until the officer pulled him away. He was holding the person until pulled away by the officer and he said, nah, don't. And then the officer grabbed him and took him to the patrol vehicle. So he was grabbing onto the EMS worker as she was trying to assist her.
I think that statement was based off of a little bit of confusion and frustration. It wasn't his intention to like impede
And
on the medical assistance.
in this case, that impediment would be grabbing the EMS, so she couldn't, or the EMS responder couldn't perform their duties because at the time the defendant had grabbed their arm.
what was EMS, what were they trying to do?
So according to the DIMS, it says EMS responder tried to replace the family member that was assisting on the left side of the defendant's mother. So they were trying to take that position.
Okay, right.
So they're trying to assist the mother who was on the gurney. And that's whenever they couldn't do that.
Keep going.
And then it says the defendant proceeded to grab EMS responder's right arm and stated, nah, don't fucking. Before the defendant could finish, the officer used an open hand technique to separate the defendant from the EMS responder.
Do you believe that arise to a clear threat? Or I think there was a lot of confusion because it seemed like two of his family members were.
What is the intent of what he is trying to do?
So
Is
there's
he-
a backstory to this because which he can explain as well because it's a bit confusing, but
we really can't get into that.
yeah, I know I can't get into
The
the
thing
backstory.
is he really trying to impede? Is he trying to help?
He was so his situation was trying to help because in a way he felt like they weren't trying to assist in the way in which they were called to assist. So it was more confusion because based off of what my client's telling me as far as these facts
Your Honor,
that are stated.
as pled, it's through criminal negligence that it's just disrupting or impeding. And in this case, it was because the EMS could not replace that family member to get to the mother who was on the gurney because at the time she had her arm grabbed by the defendant. So whether or not he intentionally was trying to impede is not the question, it's whether or not there was that impediment due to some criminal negligence. In this case, there was.
But what would you define as a criminal negligence?
He should have known that they were trying to do their duty and not to get involved.
And is it a public is it a,
And allow me to pull up the information again. And as pled and reflected in the statute, the person employed to provide emergency medical services, including the transportation of ill and injured persons. So in this case, it was the transportation of injured persons.
Can we, because I would definitely like to put everything together with the facts by watching because obviously there's camera to show exactly what happened, right?
I can see it.
Wasn't there dash cam?
do you want to delay it a couple
Yeah.
days?
There's a lot
I'm
of
done.
videos, yeah,
There
they're
are a
all
lot of
shared.
videos, so I can look at the videos and then put the pieces together to see whether,
So,
like, to see his clear intentions.
Pick a day later this week and we can have a problem.
Okay. He does need bond conditions, though, Your Honor.
I wasn't going to put any conditions on.
Okay,
I mean,
that's fine. Well, that's fine for me and my client. I just wanted to,
Yeah.
that's what he's waiting for.
okay. We have this young lady that's about to plead to the case. The problem is that she's got 5 kids, can't afford anything. Is there a way to waive all the stuff in the program?
Because a lot of those costs are community supervision costs, and I don't have the authority to waive their costs. So like SOP, I don't know if she's taken a TRAS yet or anything, but SOP,
She's, how far along is she in the program?
I think 3 or 4 months in.
has she spoken to the probation officer about her financial situation?
Well, we originally filed a financial affidavit, and then as far as conversations with her officer, she had made mention that she can't afford it anymore. Basically, at that point, she stopped doing stuff because she can't afford to do it.
Because typically my understanding was that if she brought that to their attention, they would go through and do kind of a financial plan with her and help her find lower cost options.
I think she wants to do
But I'm
that.
not sure. So she's already in the program, correct?
Yeah, yeah,
Okay.
yeah.
And
But I
she's on
mean-
docket for a violation or something?
No, she's going to plead today because she can't afford it.
Yeah, I was going to bring her in to plead it out because she can't afford it.
Would you mind emailing me her case information? Allow me to staff it with our program coordinators who can reach out to her specifically assigned officer to see what conversations they've had and what
Okay,
options
sure.
are available to her. Which makes
Does
sense.
she still want to do that, you think?
She wants the case off the record if she could stay in the program. It's just a matter of finances with her.
So let's see, let's not do it today. Give it some time, see if you guys can work it out.
Yeah,
you
she's
know?
not on docket today, so we brought her in off.
Oh, okay, great. Yeah, then just,
She lives in Louisiana, so she got
oh, that's another hurdle too.
How long is she here?
well, she's going back right after court. I mean, yeah, that's where she lives.
I mean, we can always do stuff through Zoom,
Sure.
so, or FaceTime, so there's always a
It's
way.
true, yeah. If we're not gonna plead, we can do it.
Please, she's got to be here.
Yeah, I understand that.
Everything can be achievable through Zoom. There's just no,
She wants me to look into it. I have no issue looking into.
I'll email you everything. And then, if we could find a solution that works for her, I mean, that'd be great.
awesome. Yeah. We need to be able to, there should be a way that we can work these things out. Like maybe we get some like grant funding or something to where when we have people who are in this situation, I don't know. I'm just thinking out loud. But, because I know, and I know.
Community supervision, I have access to those kind of resources. I just know it's something just need to
I want to say that I've heard that other jurisdictions also have a way that they have a workaround in these situations as well too. So,
what they do or don't have.
Right.
And I want it to be available to everyone. So we'll get to the bottom of it.
okay, cool. Yeah, just let me know if you ever need anything and then
Thanks, Judge.
Good morning, Mr. Osores. Good morning. So you're charged of driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 6 days in jail with credit for the 2 days that you've done. You need to understand a couple things, sir. Number one, that this charge is going to go on your record. It's going to be there for the rest of your life and you can never take it off. What that means is that whenever you get pulled over now, in the future, an officer, the first thing they're going to do is they're going to look at your record. They're going to see that you have a prior DWI. What do you think they're going to do if they come up to you and they smell alcohol on you? No.
Oh, no.
Shoot again. What do you think they're going to do? That's what's probably going to happen. Right. What we're doing today From now on, you were facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. What's more is you're on felony probation for a is it a third degree? It's a third degree, right?
Yes, Judge.
There's only so many times that they're going to let you slip before they put your butt into prison. What do you think they would do to you in prison? Do you have any clue what they would do to you? It's your worst freaking nightmare. It's worse than that. And you're literally. If you have a problem with drugs or alcohol, you better address it before the felony court gets involved and really takes your life for a spin. Because there are only, like I said, there's only so many chances they're going to give you before they light your butt up and just throw you into prison. Once that happens, your life is all but over. Anytime you have a felony conviction on your record, your life is all but over. It'll be nearly impossible to get a good job. No one hires felons, potentially lose the right to vote. It is a very bad thing. So you're telling me that they're going to continue him on supervision upstairs?
The whole deal was, as long as we pled to something here, and they were going to continue him upstairs. And we just wanted to get it done before he has court on Wednesday. We were just waiting for videos to come in, so we reviewed everything.
So you have to understand, you're on felony probation. You plead to this case, it's very possible they revoke your probation, put you in prison. Do you understand that?
Yes, sir.
You give up a lot of rights by entering this agreement, Mr. Osorio. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, like I said, it'll go on your record. You can never take it off. Do you understand?
It's just,
You know, we all make mistakes, right? But the idea is that you learn from your mistakes and you don't continue to endanger other people's lives. There is a $3,000 surcharge that is usually tacked on when someone pleads guilty to the DWI. I'm going to waive it now, but I'm going to tell you on a second offense, you're looking at a $6,000 surcharge, not to mention court costs. So get ready. You pick up another DWI. It's really going to go south. Do you understand?
yes, Judge, thank you.
I am going to suspend your license for 180 days. Do not drive until you get a license. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty, send you to the agreement. Good luck to you, sir.
Good to see you, Judge.
You got it.